the defendant, Michael Keatley, comes over to the Lucas home posing as a law enforcement officer with a loaded .45 caliber gun. He is looking for somebody named Creeper. Where's Creeper? He's demanding that they show him their identification, but he doesn't wait to see who they are. He immediately starts shooting them. Juan and Sergio Guitron, brothers, both of them died that night.
Michael Keatley is not guilty. This is a case of misidentification, unreliable eyewitness testimony, and circumstantial evidence. Nobody's disputing that these 6 young men were shot at all. And nobody's going to dispute that somebody went up there and did this.
11 months before these horrific crimes, the defendant tragically was a victim himself. He was robbed and shot at gunpoint. But the motive for this case simply is revenge. Did you have a nickname back in 2010?
Yeah.
What was your nickname?
Creep.
You never heard about a guy by the name of Creep? No. Never? Okay. No. So you never asked anybody about a guy by the name of Creep? No. Okay. No.
He tried to kill 4 other victims in this case. All of them that night were in fear for their lives. Fear for their lives, because this man wanted vengeance.
We waited to see what he was going to say. He asked, who's Creeper? And we're like, none of us.
I just seen him coming at us, and then when I turned around, it felt like I got shot as soon as I turned around.
We were all in a line like that, so we started shooting from this way, that way, to right, to left.
He looked at me and he pumped it again, and he shot me in my chest.
My legs and my arm.
Do you know what caused those?
Yes.
What?
45. I mean,
Were you shot in the head?
yeah.
Whose face did you recognize?
The guy that shot me.
What did you do when you saw that photograph?
I started to cry.
Because why?
Anger. It's because of Sergio and Juan.
There are factors that you take into consideration, and they're important for you to take into consideration when you consider the testimony of people that say, that's the guy.
There can be a tendency for witnesses to focus on the weapon, and when they're doing that, there's less time to focus on the face or the other features of the person that they're looking at, likely the perpetrator.
Juan goes over and shows the photograph, the single photograph on the phone, and this is already when Jose's already heard since the night before. Mike the ice cream man, he was the shooter. Juan goes over and shows it, and all of a sudden, Jose goes, that's him. That's the shooter.
He searched for the term creeper 185 times. Ocean mist. He searched for that term 92 times. Law enforcement found a composition book in his house. You'll hear that the detectives went through that composition book, and on one of those pages was written by Jan, Omar's last name, the person who has a nickname Creeper, and an address, 507 Ocean Mist.
The fingerprint at the upper portion of that photograph, I was able to identify as being made by the left thumbprint of Mr. Keatley.
And we were able to arrive at an opinion or conclusion as to whether or not that spent shell casing found at the pasture at the Keatley residence was fired from the same weapon as the 10 casings from the crime scene, or a different weapon than that fired the 10 casings at the crime scene?
Yes, I was.
What was your opinion in that regard?
It was fired in the same firearm as the other 10.
This is Michael Keatley's parents' house. He was so injured that once he came out of the hospital in February of 2010, he was never able to live alone again. His mother would have to help him wipe himself after he used the restroom. But he's on a porch shooting 6 young men.
He had a brace on his right hand. A lot of times he was wearing it with the sling on there. He wasn't really able to use his right hand. He was mostly using his left hand.
Is there any possibility that on November 25, he could extend or open the fingers of his right hand without the use of his left hand?
No.
On a scale of physically possible to physically impossible, what is the likelihood that his right hand fingers and thumb could independently open without the use of his left hand on November 25?
Impossible.
Raise your right hand, please. Do you swear affirm any testimony you give will be the truth, the whole truth, and nothing but the truth?
Yeah.
So I want to ask you if you've had sufficient time to discuss your decision with your attorneys.
I have.
Have you made a decision?
Yes, I have.
What is that decision?
I'm not going to justify.
Consider everything in its entirety. Consider what is reasonable in your life experience and your judgment. And I suggest to you that if you proceed with your analysis in that fashion, you will return verdicts of guilt beyond a reasonable doubt.
Your Honor, Mr. Keatley is going to waive closing argument. He's going to rely upon the evidence as presented to the court. He's had extensive conversations with Mr. Gonzalez, with me. He knows that I am completely prepared to do this closing argument, and he has instructed me not to.
You just heard what Ms. Gowdy has informed the court, that she, although she is prepared, ready, willing, and able to present a closing argument on your behalf, that she does not intend to do so because you have instructed her not to. Is that correct?
That is correct.
Has anyone... That is your decision.
That is my decision. Yes, sir.
No one has forced you or threatened you in any way to make this decision?
Not at all.
What a case. All the evidence is in so many issues. Thank goodness. Still with us in Cleveland, Ohio, criminal defense attorney Ian Friedman. And I want to start with where we are in the case. The jury sent a note at the end of the day saying we have not reached a verdict, but there are a couple or a few jurors who just want a little time to reflect tonight. Does that tell you anything?
No, I mean, this is, a lot of these jurors have never been in a courtroom. They've never been asked to deal with something as serious as the death of 2 people and the injuries to 4 others. This has been some heavy stuff that most people will never experience in their life, and it's exhausting. It takes an emotional toll, and so they just needed some air. They had to decompress a little bit. Jurors need that time. Once the case goes to them, they're the boss, really. They get to tell the court when they start, when they finish. And so, no, I'm not terribly surprised because of the nature of the case.
All right. I believe the key to this case is the creep factor. Okay. There's this guy, Creep, and the defendant, they have linked him by his computer searching for Creep. He's got this little notebook at home. It's got his fingerprint on it right next to the name of the man whose nickname is Creep with his address. The testimony of these survivors of this horrific shooting, we're all talking about somebody who shot them who's looking for Creep or Creeper. To me, I can't get beyond that. To me, walks like a duck, creeps like a duck, it's a duck.
It's a duck. That's right. I couldn't agree with you more. And you're talking about all of the kind of facts leading up to the shooting. And then throw into the mix the fact that the very next day he went to get his vehicle painted so that it couldn't be recognized. This was an extremely difficult case for the defense. Sometimes, the defense lawyer, particularly if they're appointed, or not even just then, but what do they have to lose, right? So this case was a mountain to climb for them. Might as well try it. Might as well try and get some appellate argument to maybe get it circled back and get a deal someday, down the line. I believe this is an insurmountable case. Too much evidence pointing to guilt on this one.
Do you think any of these jurors might feel any level of sympathy for the defendant? He was the victim of a robbery. Yeah. He was shot. He's somewhat disabled. They had the experts coming in saying how he couldn't do this, he couldn't do that. His mom has to wipe him, or had to wipe him when he came back from the hospital. Really can't use that right hand. When he raised his right hand, it was kind of like this, kind of crunched over. Anyway, any of them might feel any level of sympathy that might play a role in deliberations?
Yeah, I think that inevitably they're going to feel sympathy for him. He was a victim himself, and he now has to carry the scars of his victimization for his entire life. So what that is, as you know, but just for your viewers, it's what we call jury nullification. And that's where we're asking the jury, or you're hoping that the jury is going to say, yeah, you know what, he did it, but there was a good reason to do it. But I think that the prosecutor, even though they didn't get their final close because of the waiver of the defendant, the prosecutor did a nice job addressing that and trying to say, look, ladies and gentlemen, yeah, he was victimized. Yes, he was treated. Yes, he did go through all these surgeries. But you heard him say it, but then he took justice into his own vigilante hands. So they've tried to do a good job at saying, it's okay to feel sympathy for this person, but you still can't go out there when a crime has not been solved and do it yourself. So,
and the other part of this, Ian, though, the other part of this is, I mean, these victims weren't involved in the robbery. So he's shooting people that have no connection. Do you think the equation would be any different if, in fact, he had shot someone who was actually responsible for shooting him?
Absolutely. No question about it. And I think had the prosecutors gotten their final close, they would have said that. They would have said, just as upset and traumatized as he because he was victimized, these 6 people were also, and they had nothing to do with anything. Creeper, if Creeper was involved in the initial shooting, wasn't even there. These were 6 bystanders. End of story. This case for him, unfortunately, a bad case for the defense got worse when the defendant dictated what they were going to do by not closing. This is going to be one that the defense lawyer is never going to forget.
All right. Ian Friedman, great to see you again. Thanks so much.